New updates in the Sean Diddy Combs case. The rapper's lawyers make a new bid for bail. His team and prosecutors spar over a gag order about what can and cannot be said about this case. And Busta Rhymes weighs in too on how people should be thinking about and responding to Combs' legal saga. His answer may surprise you. Welcome to Sidebar, presented by Law&Crime. I'm Jesse Weber. Hey everybody, this is a Law&Crime legal alert. A mother was recently awarded millions of dollars in a lawsuit against baby formula manufacturers after her premature baby was diagnosed with necrotizing enterocolitis, or NEC, after receiving bovine-based formula. The lawsuits allege that Enfamil and Similac premature formulas are linked to NEC, but manufacturers, they failed to warn the public of the risks and targeted them with false advertising. So if your premature baby was diagnosed with NEC after they were fed Enfamil or Similac, you may qualify for compensation. And one of our legal sponsors is partnering with Wagstaff Law Firm. This is a national firm renowned for their expertise to ensure that eligible claims are thoroughly presented. Visit babyformuladamages.com/sidebar to answer less than 10 questions and check your eligibility to file a claim. All right, so we have some updates for you now in the Sean Diddy Combs legal saga, as the embattled rapper and music producer sits in the Metropolitan Detention Center as he waits trial, which is currently scheduled for May of 2025. As we know, he's facing sex crimes charges of racketeering conspiracy, sex trafficking, transportation to engage in prostitution. Now, the first update for you is actually regarding his bail. And as you might recall, two different judges denied him pretrial release, denied him bail. Some of the major factors that were considered by the court was that he's a danger to society, a flight risk, and perhaps most importantly, that he allegedly had been improperly contacting witnesses. Now, Combs has denied these accusations, and in fact, in a recent filing with the Second Circuit Court of Appeals, where he is appealing this bail issue after, again, he was denied by two judges pretrial release, he says, and this is an interesting argument, Mike Jeffries, the former head of Abercrombie & Fitch, who was just arrested for sex trafficking pursuant to federal charges in New York, why does he get bail? Because he was let out in bail. That's an important point. In fact, in Combs' filing, he states, Mr. Combs is entitled to release, which has been granted to many similarly situated defendants, including just yesterday, a CEO accused of sex trafficking dozens of young men, including through witness intimidation. The government's request for detention is not based on any genuine risk of danger or obstruction. It is based on a desire to punish Mr. Combs. Tell you what, making that comparison, it's a pretty compelling argument. And I'll tell you what, let's go a little bit more into this legal brief to the Second Circuit, because I actually think from my legal point of view, Sean Combs' team makes a number of strong arguments for why he should be released. So let's get into this. So his lawyers start by saying the government failed to present clear and convincing evidence below that this is the rare case justifying pretrial detention. It offered no legitimate reason why the proposed release conditions would be insufficient to mitigate the risks it claims exists. So clear and convincing evidence means you're proving something is substantially more likely to be true. It's a lower standard than beyond a reasonable doubt. It's kind of like a middle standard. And Combs' lawyers are like, the government hasn't shown why detention is necessary here. First off, they're saying the government is citing the 2016 tape of Combs purportedly beating his ex-girlfriend Cassandra Ventura in a hotel hallway, that is proof of his dangerousness should he be allowed out. But Combs' lawyers say this is an 8.5-year-old video, and quote, although Mr. Combs' conduct on the video is indefensible, he's apologized for that conduct, which must be evaluated in the unique context of the toxic romantic relationship in which it arose. But regardless, that conduct and that relationship are long in the past. The conduct in the video is not evidence that Mr. Combs will engage in any future violence. Now, the government would say that she was actually escaping one of these freak-offs, which is a key component of the indictment, and they've also said that these freak-offs extended much past 2016, that it was happening also, I believe, in 2024. But despite that, Combs' lawyers are saying that the conditions that we're proposing in our bail package, such as no contact with any women other than family members and his lawyers, that negates that risk that he would be a danger to women. And when it comes to the allegation that Combs was reaching out to witnesses improperly, well, they're saying, you know what, even the government says, yeah, Combs was reaching out to one of the witnesses, but this was months before the lawsuit was filed, or that specific lawsuit was filed, his lawyers say his contacts were in no way obstructive. And the fact that the witness and Mr. Combs had 128 phone contacts, that doesn't prove anything. And they also say, quote, of course the government has the actual communications and would describe them for the court if they truly revealed obstruction, but for the third time, it has failed to describe them because they reveal nothing of the sort. So this idea of what really is the government's evidence about obstruction. And then Combs' lawyers say the government can't even argue that he was engaging in obstruction by contacting grand jury witnesses. Quote, one witness contacted Mr. Combs, not the other way around. The government fails to address this, nor does it respond to Mr. Combs' argument that the bare fact that two individuals spoke is not evidence of obstruction because the government cannot prove Mr. Combs intended to tamper with these witnesses. He did not. The government's silence underscores why the district court erred in relying on the government's unfounded assertions. So Combs' lawyers are also saying if you look at the past cases, you need to have substantial evidence of obstruction in order to justify pretrial detention. And they say the case that the government is relying on, saying you only need to show one episode of witness tampering to justify detention, Combs' lawyers say no. That case they're relying on was about a decision to revoke bail once it was granted, not ordering detention at the start of the case. The defense says the bar to have bail revoked is much lower. You don't need as much evidence to justify that. It's not clear and convincing. That's not the standard as we have with Combs' issue here. So that's a really interesting argument. And despite that, Combs' lawyers are saying in that case that the prosecutors are relying on, the government in that case, they had 3 days of hearings, they had 12 witnesses, they had all this proof to show that the defendant had engaged in witness tampering. Here, there was no hearing, there was no witnesses. They're basically making the argument that the court just took the government's word for it, that Combs was obstructing. And Combs' lawyers say the government has no actual evidence, just the allegations in the indictment. And they say that's a problem. You can't rely on the indictment. They say, quote, an indictment at most reflects a grand jury's finding of probable cause that the defendant committed a specific offense. It does not reflect any finding of clear and convincing evidence, which is the standard required to justify detention. And here it is unclear whether the grand jury ever even found probable cause to believe that Mr. Combs committed any witness tampering. There's no obstruction count. That's true. He's not charged directly with obstruction. What they're arguing is that, yes, the grand jury, they found probable cause of racketeering conspiracy, and yes, obstruction is one of the underlying listed acts of that charge, but there were a lot more that were listed. And the grand jury didn't necessarily find that obstruction was committed. They could have said there's probable cause of racketeering because of sex trafficking, because of bribery, because of arson, because of kidnapping. Maybe not necessarily obstruction. They didn't say that. So these are all these other underlying acts that the grand jury could have relied on to say that this is a racketeering conspiracy. I think that's a good point. And then Combs' team doubles down that their bail package, it's sufficient. We've mentioned this before on Sidebar. Home confinement, 24/7 monitoring by a private security team, $50 million bail, no internet, no phone use, limited visitors. The visitor logs would be provided to the court. And this part's interesting because you see the government had previously argued that it's not fair to have a two-tier justice system where Combs would be permitted to stay free on sex trafficking and racketeering charges because he has the financial resources to turn his home into a private prison, whereas you have a defendant of lesser means who couldn't put forward that package, and therefore they would be denied bail, they would be locked up while waiting trial. That's not fair. Combs' team says, well, wait a second. We're offering this package and these conditions because Combs is wealthy. The government said he's a risk of flight, he's a danger because he has this money and resources. So the reason that this bail package looks like this, the reason it's so expensive, the reason he's essentially turning his home into a prison is because this would be the only way to ensure all of the concerns the government has. That's why it looks like this. The government, they say, can't have it both ways. It can't use Mr. Combs' wealth as both a detention sword and shield. Another good argument, in my opinion. And Combs' lawyers say when it comes to flight risk, the government can't prove it. Quote, Mr. Combs clearly intends to face and contest the charges, not flee. nor do significant penalties and serious reputational harm demonstrate any risk of flight, the government has already destroyed Mr. Combs' reputation, and his only hope is to stand and fight, which he intends to do not only on this front, but also against dozens of civil lawsuits. As for possible penalties, none could compare to the prospect of abandoning his 7 children, his mother, and other family members, as well as the remarkable career he has built for himself. So that's his argument for why bail should be granted and why he should be released pending trial. Now, having said all of that, you might have seen on a previous sidebar that we discussed this, how Combs has actually requested that the Second Circuit, again, the court he's making all these arguments in front of, that they don't do anything yet. They don't act on his appeal yet. It's called hold the appeal in abeyance. And that is because Combs says, wait. I don't want you to do anything. I want to first ask the new trial judge overseeing this case, Judge Arun Subramanian, if we can get bail. Let me go to him first. Let me try to convince him. If that doesn't work, then yeah, we'll come back to you guys. And I'll tell you what, based on the court docket, it appears the Second Circuit granted that motion. So now it looks like that bail issue is going to go in front of the new judge. Now, let me get to the heart of another big update in this case. You might recall, if you've been following this case, that back on October 10th, Combs had appeared in front of Judge Subramanian at a hearing. And at that hearing, a number of issues were discussed, including discovery, a potential trial date was set for May 5th, 2025, but there was something else that was discussed, a gag order. You see, Combs and his legal counsel, they have accused the government of engaging in misconduct. In a filing leading up to that hearing, Combs' defense counsel blamed the government, more accurately, the Department of Homeland Security, of leaking information and making inappropriate comments to the media. And they asked the court to schedule an evidentiary hearing to get to the bottom of what's going on here. More specifically, they allege that the Department of Homeland Security agents leaked that infamous 2016 videotape of Combs and Ventura that I mentioned before. And they say this leak happened after the raids on his properties in March, and this is before he was ultimately arrested in September. But they're saying Homeland Security leaked that information. And they also argue that Homeland Security agents were making statements to the media too that were inappropriate. So prosecutors responded to this by saying, first of all, our office had nothing to do with this. Okay, we had nothing to do with a leak of any information or making any of these comments. But number two, it's our understanding that the Department of Homeland Security, they didn't have the 2016 videotape prior to CNN publishing it. So Judge Subramanian reserved ruling at the time on whether to order an evidentiary hearing to sort all of this out. And by the way, potentially whether this 2016 tape, if it was leaked, whether it has to be suppressed, meaning it can't come into trial. That would be a huge win for Sean Combs. But Subramanian indicated he wants to review each side's arguments, which are due by November 7th, and then he'll see if a hearing is warranted. But what the judge did do is agree to a gag order. And this was something the defense had asked for as well. They want to stop the government from saying anything, from disclosing any material. The federal prosecutors at the hearing were like, okay, we'll agree to that, but the defense, they need to agree to a gag order too, because they say the defense hasn't been so clean in this. They called out Combs' attorney Mark Agnifilo for doing an interview with TMZ right after Combs was arrested, where he called the criminal case, quote, the takedown of a successful black man, essentially making this look like a racist prosecution. So Judge Subramanian said both sides have to work out a gag order. Okay, and that brings us to today's update. So in a letter to the court, Combs' defense counsel has addressed this gag order and what has been happening behind the scenes. So Combs' lawyers are saying, look, court, we have this proposed order. We think it's designed to prevent leaks. We think it's designed to prevent information from being made to the public and the media. And then it says, quote, the proposal also reinforces the parties' existing obligations under the protective order and local criminal rule 23.1. We've discussed this local rule before. It's a local rule for the Southern District of New York where this case is being prosecuted. And it explains how lawyers and government agents and officers, they can't release non-public information about a criminal case if there is a significant danger that it would affect a defendant's constitutional right to a fair trial or it would prejudice him or the case in some way. Now, Combs' counsel indicates that they weren't able to come to an agreement with prosecutors on this proposed gag order. This is what the defense wants this order to look like. It's not an agreement between the two sides. Quote, unfortunately, however, We are unable to submit Exhibit A as a joint proposal because after extensive back and forth since the October 10th conference, the parties were unable to reach agreement on the order. We did narrow the disputes, however, and understand that most, but not all, of the language in Exhibit A is acceptable to the government. At this juncture, the court's intervention is critical because agents involved in the investigation have continued their leaks and their damaging and false information to the press in the wake of the October 10th status conference, only heightening the need for the gag order to be issued as soon as possible. Wow. So basically accusing the government again of leaking information or saying things that are inappropriate. So in this letter, they cited as an example of this how Deadline.com reported in an October 15, 2024 article that a law enforcement source with knowledge of the case stated, referencing the defense's October 15, 2024 motion, this is all about shaming the alleged victims. It's part of the defense offense course of action, and they'll try anything. So the argument is that out-of-court statements like this could potentially affect a jury pool. It could affect how Combs is able to present his case or maybe what witnesses are called. And everyone, by the way, can agree that out-of-court statements could potentially be problematic. And to be clear, Combs' defense team is not blaming the prosecutors of allegedly doing this, but only authorities that are connected to the investigation like Department of Homeland Security. But they're saying, look, court, this is the problem. We and prosecutors, we can't agree. Combs' lawyers say, quote, "The government continues to resist language that will ensure that the order covers all the agents who may be exposed to grand jury materials and other confidential information. The government wanted the order only to cover agents assigned to the investigation rather than any agents who acquire confidential information about the investigation and objected to the specific reference to the Department of Homeland Security. These objections would defeat the purpose of the order. Whether an agent is officially assigned to the investigation or not should not matter. So Combs wants this gag order to apply to anyone who may be in a position to potentially leak information." So the government responds in a letter of their own to Judge Subramanian, and they're basically saying, court, adopt our language, adopt our gag order. They say this is the main disagreement we're having. The government writes, "The only remaining disagreement between the parties is the language concerning who would be bound by the order. The government's proposed order reflects the reality that the government has two separate obligations: maintaining the secrecy of grand jury material and complying with the directives set forth in Local Criminal Rule 23.1. The parties agree that the government attorneys assigned to the matter and staff members working under their supervision or at their direction are bound by both obligations." They're meaning the prosecutors and their team. However, the parties disagree about the extent to which law enforcement agents and/or officers may be bound by those obligations. And the prosecutors say that Combs' proposed gag order, it's way too broad. That to have a gag order apply to any local and federal law enforcement agents assisting any aspect of the investigation or prosecution of this case and any related grand jury proceedings, including but not limited to the Department of Homeland Security, that is plainly overbroad. Prosecutors argue it would require the government to be held accountable for potentially thousands of agents in an independent law enforcement agency over whom the government has no authority or oversight. Indeed, the United States Department of Homeland Security employs over 200,000 individuals and includes the investigating agency here, Homeland Security Investigations, in addition to multiple other law enforcement agencies. And they say these agencies have no role in this case whatsoever. Such an order would simply be unenforceable. So what does the government propose? What do they suggest? They write, quote, "The government proposes that the court order that 1. Local and federal agents who have access to grand jury material not disclose that material in violation of Rule 6E, and 2. Local and federal agents assigned to the case comply with Local Criminal Rule 23.1, the one that we mentioned. We've talked about that. But by the way, Federal Rules of Criminal Procedure Rule 6E, that explains that neither prosecutors nor anyone who receives grand jury material, they can't discuss or release information about that. So that's what governs that. And prosecutors have attached their proposed gag order to this letter as well. So what happened next? Well, Combs' defense lawyers responded to this letter from the government, and they are not backing down. They write, quote, "As Mr. Combs requested, the order should cover all local and federal law enforcement agents assisting any aspect of the investigation or prosecution of the above referenced case and any related grand jury proceedings, including but not limited to employees of the Department of Homeland Security." They say that that request is not plainly overbroad, but specifically orders any such individuals not to directly or indirectly disclose any grand jury material. or other information that would be covered by that local rule, which would include agents making false and damaging statements about Combs that would undermine his right to a fair trial. The purpose of the order is to end what has been a demonstrated history of law enforcement leaks, as well as false and damaging public statements by agents. And Combs' defense team says that Homeland Security especially, they need this order. They need to be put on notice of what they can't do. And they say that this problem is a lot more widespread than we think. Quote, Mr. Combs acknowledges the government's representation that any sensitive information is primarily housed at HSI New York in a restricted database that is accessible only to 3 assigned agents to his case. However, the government ignores the practical realities of how its investigation has unfolded and will continue to unfold, and the history of damaging statements to the press. As just one example, in executing search warrants, many of which were obtained using grand jury materials and other non-public information, the government has relied on multiple other government agents and employees beyond the 3 assigned agents. That cannot be disputed. So again, Combs is asking for a more inclusive, more broad order that would address these concerns. And Combs' lawyers are saying, we need this gag order now. We need it fast. And by the way, Judge Subramanian agreed that there needs to be an order put in place, but they need it now. They need it entered now because Combs' legal team says, quote, the prejudicial leaks will only continue undermining Mr. Combs' right to a fair trial. Now, as Judge Subramanian has to sort all of this out, and as we ironically are focusing on people talking about the case, a well-known figure from the hip-hop world has jumped into the mix. Well, sort of. Busta Rhymes. Now, he has just spoken out in a very important way about this case. And to be clear, a gag order doesn't apply to you or me or celebrities, only government officials and lawyers in the case. So Busta Rhymes, he can talk about this. And he was speaking with Extra at the premiere of Venom, The Last Dance. And he said, quote, his situation, meaning Combs' situation, is not a hip-hop situation. And I also would like for everyone to be mindful of the thirst and the urgency and the need to speak on the situation. I think a lot of times people don't realize how insensitive it could be to have opinions on things that you have no understanding of outside of what you're being told. He continued, I'm going to reserve my opinions and I'm going to wish the best for everyone involved. The one thing that we should take away from what I'm saying is everybody probably need to mind their damn business until the truth is undisputed. At that point, justice needs to be served accordingly for everyone involved. And he has a point, right? You know, this might be surprising to hear, but Sean Combs is innocent. Not only has he not been found guilty yet of any crime in connection with this investigation, but he hasn't been found liable with respect to any of the sexual assault claims that he's facing in any of these lawsuits. These are all allegations, serious allegations, sure, but allegations nonetheless. He does have a right to be heard. He has a right to present a defense. He has a right to a fair trial, a right to an impartial jury. So we shall see where all of this plays out. That's all we have for you right now on updates in the Diddy case. Thanks so much for joining us here on Sidebar, and please subscribe on Apple Podcasts, Spotify, YouTube, wherever you get your podcasts. I'm Jesse Weber. I'll speak to you next time.